Thank you. Good evening, ladies and gentlemen. Thank you for joining us. We're grateful to the MCIA to provide a platform to us during this India ADR week to discuss and probe into various legal concepts arising from the law of arbitration in India and abroad with distinguished legal minds who have experienced the complexities of commercial transactions involving multi-party claims and multi-party arbitrations. Today, we delve into a critical legal concept within the realm of arbitration under Indian law as well as globally, the joinder of third parties in arbitration, primarily in the context of the group of companies doctrine. Arbitration, with its efficiency and impartiality, is a preferred mode of dispute resolution. Yet, dispute often involves not only the contracting parties, but also affiliated entities. The group of companies doctrine recognizes that groups of interconnected companies functioning as a single economic unit should not be excluded from arbitration. This doctrine hinges on demonstrating clear interdependence, control, and unity of interest among entities within the group. It ensures that the true nature of corporate relationships is acknowledged in arbitration. In this context, it is important to note that the recent Cox and Kings judgment by the Supreme Court of India has sparked significant debate within the legal community. In that, the Supreme Court made a reference to a larger bench of the Supreme Court to deliberate on the correctness of the application of the group of companies doctrine and joinder of third parties in an arbitration in the judgment of the Supreme Court of India in chloro controls. By allowing non-signatory entities to participate in arbitration under this doctrine, we maintain justice and fairness, preventing parties from using corporate structures to evade their obligations. However, this is a fine line that must be tread cautiously. In the following discussion, we will explore this doctrine, taking into account recent developments and delve into pertinent case law. I encourage your active engagement to deepen our understanding of this critical legal concept. Thank you, and let us begin our fruitful discussion with the introduction of our three speakers. To begin with, we have Mr. Zubin Behramkamdin, a legal luminary with 3 decades of experience in the legal fraternity. He has served as an arbitrator in numerous cases and rendered awards in over 14 arbitrations. His expertise spans across various domains, from construction and e-commerce contracts to financial institution recovery actions and insurance disputes. In the courtroom, Mr. Behramkamdin has excelled as a senior counsel designated by the Bombay High Court. He has represented clients in commercial and corporate disputes, including winding up petitions, banking transactions, and he has also been involved in substantial litigation pertaining to industrial law. In the field of arbitration, Mr. Behramkamdin has an impressive track record. He's handled a multitude of cases, including international arbitration. He's appeared before eminent former Chief Justices and retired Supreme Court judges, and represented prestigious clients, including major banks and corporate giants. In sum and substance, Mr. Behramkamdin is known for his arbitration prowess, courtroom victories, and an extensive list of reported judgments. Our second speaker, Mr. Rashmin Khandekar, is a distinguished legal professional of exemplary repute. He holds an LLM from the London School of Economics with a specialized focus on comparative constitutional law, international commercial arbitration, and trademark law. Mr. Khandekar embarked on his legal career in 2010, starting in the chambers of senior advocate Venkatesh Gold, and went on to establish a thriving independent practice. His core specialization lies in commercial litigation, underpinned by a diverse clientele. Furthermore, he has earned recognition as an authority in the domains of arbitration and intellectual property law. The Bombay High Court has entrusted him with the role of arbitrator in over 50 commercial disputes, and he has contributed his expertise by being associated with the Indian Merchants Chamber with respect to causes on arbitration. Predominantly, he appears before the Bombay High Court, arbitral tribunals, and the National Company Law Tribunal in Mumbai. Last, but certainly not the least, our third speaker, Mr. Vijay Purohit, is a dispute resolution partner at P&A Law Offices based in Mumbai. Mr. Purohit completed his integrated BA LLB from the Gujarat National Law University in the year 2009. He has over 14 years of experience in dispute resolution. He is a fellow of the Chartered Institute of Arbitrators in London and holds its coveted diploma in international commercial arbitration. Mr. Purohit has been a part of and conducted several arbitrations in the construction, oil and gas, energy, and e-commerce sectors. He has appeared before courts in matters arising out of and in connection with arbitration. And in fact, recently, he added another feather to his hat by having appeared and argued certain aspects of Indian law in an ICC-seated arbitration in Chicago. As you can see, we have a diverse and accomplished lineup today. So without further ado, let's get started with our first speaker. Mr. Behramkamdin, what is the group of companies doctrine? How does it operate? And in what circumstances has it been applied under Indian law?
Thank you for the introduction, Faizan. I'm very happy to be here and be a part of this discussion today.
Thank you, sir.
So the group of companies doctrine has really gained recognition in the Indian legal system by the Supreme Court judgment in the case of Chloro Controls versus Severn Trent. This was a judgment given in 2013 by the Supreme Court. And at that time, I mean, it's easy to analyze judgments, discuss them and criticize them later, especially the more time that passes, the more you can talk about them and criticize them. But at that time, it was a path-breaking judgment. And even the Supreme Court itself has said in a number of places that this doctrine is a doctrine which should be applied only in exceptional circumstances. It's something that what was exceptional at that time may not be exceptional today. But this is not really, you can't blame the Supreme Court for that. They are not to know what is to take place in the future. So this was a case really under Section 45 of the Arbitration Act, where the lower court had directed parties to go to arbitration under Section 45. And there was an appeal in the Supreme Court. This, of course, obviously, therefore, related to the New York Convention. And there were a number of companies involved in this matter. So it had originally been filed as some kind of a derivative suit with the plaintiff having joined a number of other companies in the matter. There was a shareholders agreement, or what Supreme Court sometimes calls the joint venture agreement, which was held to be the principal agreement in that case. And then there were many ancillary agreements. All the companies had signed one or more of these agreements except for respondents 3 and 4. So there was something like a license agreement. There was something called an international distributor agreement. There was an MD agreement, which is managing directors agreement, etc. So basically, there was a joint venture between the first and second respondents with the appellant company and its proprietor IR9 on the other side. The Supreme Court stated that all the agreements had different clauses and this thus discussed each agreement in the judgment itself. So if you go through the judgment, each and every agreement has been set out over there. And the principal agreement, which is the shareholders agreement, had a clause for an ICC arbitration in London. Some of the other agreements also did have an arbitration clause in them, but 4 agreements had absolutely no arbitration clause in them at all. So this is the situation. Therefore, there are a large number of companies involved, large number of agreements involved. Every party was not a party to each of those agreements, and the arbitration clauses were all different. It was in this setting that both sides made their relative cases, put forward their cases. So the appellants argued that the parties had a right, any party had a right to go to the civil court for redress, like they had done, except if there was a bar under Section 9 of the CPC. They pointed out that many of the companies were not parties to the arbitration agreement, and in fact pointed out that many of the agreements did not even have an arbitration clause in the first place, and that the different agreements were obviously signed by different parties. The respondents inter alia argued that the entire suit was regarding the scope of business of the JV company. So the respondents structured their argument a little better. They pointed out that this was all about the JV and the business that the JV did. The major dispute was relating to the JV agreement, which is the shareholders agreement. They pointed out that respondents 3 and 4, who had not signed any agreement, had wrongly been added just to obfuscate the matter. And they pointed out that performance of all other agreements were dependent upon the principal agreement itself. So they said these are ancillary agreements, really. And one of the main arguments which was made there was that Section 45, unlike Section 8 at that relevant time, had these words, the words which were that one of the parties or any person claiming through or under him. So the words through or under him were said to be crucial. And they said that it is for this reason that we are asking for a reference, even in respect of non-signatories to the arbitration agreement. The original intent of Section 45 and this phrase, as per the Supreme Court, was there are a number of things they say. They say, firstly, a person who succeeds by operation of law to the rights of the signatory. So that person could have the benefit of this phrase. Secondly, there was a party who gets substituted in the contract due to a statutory or consensual novation. That person would also have the benefit of this phrase and could therefore refer to arbitration. A party who assigns to another the underlying contract with the agreement to arbitrate. So this was the third circumstance. In other words, a party who steps into the shoes of another. And fourthly, a party who was in reality, the Supreme Court says, always a party to the contract, although not named in it. Thereafter, in paragraph 71, the Supreme Court recognizes that the group of companies doctrine has been applied by English courts. And Russell on arbitration was also cited. I just want to read out a little bit from paragraph 71 of the judgment, where they say that though the scope of an arbitration agreement is limited to the parties who entered into it and those claiming under or through them, the courts under the English law have in certain cases also applied the group of companies doctrine. This doctrine has developed in the international context, whereby an arbitration agreement entered into by a company, being one within a group of companies, can bind its non-signatory affiliates or sister or parent concerns if the circumstances demonstrate that the mutual intention of all the parties was to bind both the signatories and the non-signatory affiliates. This theory has been applied in a number of arbitrations so as to justify a tribunal taking jurisdiction over a party who is not a signatory to the contract containing the arbitration agreement. This is from Russell on Arbitration, 23rd edition. Thus, the Supreme Court came to a conclusion that a non-signatory can be subjected to arbitration if the transactions were with a group of companies and there was a clear intention of the parties to bind both the signatories as well as the non-signatory parties. In other words, the Supreme Court said the intention of the parties is a very significant feature which must be established before the scope of arbitration can be said to include the signatory as well as the non-signatory parties. The Supreme Court, of course, as I mentioned earlier, has put in a couple of caveats, one of the most important ones being that this should be done only in exceptional circumstances. Now, of course, I don't find fault with the Supreme Court for saying this, but I want to point out that what is in certain circumstances or at a certain time an exceptional circumstance may become quite an everyday occurrence with the passage of time. So with companies evolving, with transactions evolving, things getting more complex, etc., this whole concept of group of companies may not be so rare anymore. But the Supreme Court was not to know that at the relevant time. And the Supreme Court has therefore at that time laid down certain tests. One is there should be a direct relationship with the party signatory. The second one is that there should be a direct commonality of the subject matter. The third one is that the agreement between the parties should be a composite transaction. And the fourth one is that the transactions should be one where there is a common object, and performance of the main agreement may not be feasible without performance of the ancillary agreements.
Right, sir.
There's one more clause, of course, which they have said, whether a complete reference of such parties would subserve the ends of justice. And this is, of course, very important, because what they were trying to say is that if you have a group of companies like this, and if you have transactions involving all the companies, it makes sense to go to one arbitration and have the issues of all parties resolved together at the same time, rather than having different people go to different courts and get perhaps conflicting judgments and have delays, etc., in the matter. And this is basically what the concept is. Are we running short of time, Faizan?
Yes, sir, of sorts.
Okay. So the only other thing I want to point out is that the Supreme Court did say that this doctrine has been accepted in some countries like the UK and France, but has not been accepted by others, like Switzerland has not accepted this doctrine at all. And of course, thereafter, the judgment in chloro-controls has been followed in other cases, and the concept has been expanded a little more to include economic entities who have common economic policy, etc. But I'll hand it over now for the next question.
Thank you so much, sir, for your insightful explanation on this doctrine. Now we'll turn our attention to another significant legal aspect. Mr. Khandekar, we would like to hear your perspective on a recent landmark case. What is your take on the Cox and Kings judgment? And for the benefit of our audience, could you also explain the issues and facts considered by the Supreme Court?
Yeah, sure. First of all, thank you for your introduction and thank you for having me here. I hope I'm audible.
Yes.
Am I audible? Yes. Okay.
Yes.
So the judgment in Cox and Kings obviously, in a sense, frowned upon the judgment in chloro-controls. Mr. Behramkamdin has already told you what broadly the judgment in chloro-controls dealt with and what the group of companies doctrine was. So there were two aspects of the Cox and Kings judgment. And if you could actually just put up on the screen for the benefit of the audience, the reference questions which were framed, because there was a majority opinion of the Chief Justice, and there was an opinion of Justice Suryakant, who was also on the bench on that judgment. And these were the questions which were formulated by the Cox and Kings court. I just want to, so that everybody is on the same page, I want to read what these questions as they were formulated. So the majority judgment by Justice Ramanna formulated two questions, being whether the phrase claiming through and or under in sections 8-11 could be interpreted to include group of companies doctrine, and whether the group of companies doctrine as expounded by the chloro-controls case and subsequent judgments are valid in law. So this view, or rather this reference, was in that sense questioning the very existence of the doctrine of group of companies in Indian jurisprudence. Whereas Justice Suryakant took a slightly more, if I can call it as a tempered approach, and the question that he had formulated were as to whether the group of companies doctrine should be read into Section 8, whether it can exist in the Indian jurisprudence independent of any statutory provision, whether the group of companies doctrine should continue to be invoked on the basis of the principle of single economic reality, whether the group of companies doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties, and finally, whether the principles of alter ego and piercing the corporate veil can alone justify pressing the group of companies doctrine into operation, even in the absence of implied consent. So this was what was framed. Why was this framed? This was essentially framed because Mr. Behramkamdin did mention that at that time in 2012, this was the first judgment which took the view that group of companies doctrine should be incorporated as a part of Indian jurisprudence. However, the contours of how it should be incorporated, what is it required to actually address, was actually undefined in the judgment. The judgment kept it broadly in that sense open. And the problem was that because of this, the reason particularly for the reference was that there were several judgments after the judgment of chloro-controls, which interpreted chloro-controls in far different ways. The utilization was quite varied. In fact, one of the judgments, which is Cheran Properties, in fact, utilized the group of companies doctrine at the stage of enforcement. And it actually enforced the award against a party who was not a party to the arbitration agreement. So, I mean, it had wide ramifications and there were no contours. There were no sort of, it was not as well defined. So, which is why in that sense, the Cox and Kings court had to make that reference. What was Cox and Kings? Cox and Kings essentially was a judgment where there was an agreement relating to a software licensing between the applicant and the respondent. There were 3 agreements which were entered into for this very purpose. The agreements were, and I'll just sort of set them out, called as the Software License Support Agreement, which was the first agreement. The second, in short, was called as the General Terms and Conditions Agreement. And the third was an agreement to customize the software. Now, respondent was to customize the software for the applicant. The contract, as time sort of went by, there were disputes between parties. First, arbitration was invoked by the respondent. Then the arbitration was invoked by the appellant because there was some NCLT proceeding. Let's not get into it because those are not facts which are really relevant for today's purpose. But what is material is that during the course of execution of the contract, respondent number 1 called upon respondent number 2, which was the parent company of the respondent number 1, to help the applicant with the execution of the contract. In that context, respondent number 2, in fact, gave certain undertakings, in fact, gave certain commitments to the applicant. And when the dispute arose, the dispute was inseparable between respondent number 1 and 2 on the one hand and the applicant on the other hand, which is why the applicant contemplated and, of course, relied upon the group of companies doctrine when the matter was in the Supreme Court to say that, look, there has to be a holistic resolution of this dispute. You can't sort of keep respondent number 1 and respondent number 2 separate. Respondent number 2 is nothing but a parent company of respondent number 1. And it is in that context that the Cox and Kings court was required to examine the chlorocontrols doctrine or other group of companies doctrine which was set out in chlorocontrols, and it found both courts, I mean the majority judgment as well as the judgment of Justice Suryakant, found serious faults with the judgment, if I can call it so, with the chlorocontrols court, and that is why in that sense the reference was made. This is in short, I think, if I can, I mean, you can go on and on about Cox and Kings, but this essentially was something which had arisen in Cox and Kings and why the reference was made.
Thank you. Thank you for dissecting the judgment for our audience. If I may pick your mind further, what has been your experience as a counsel and as an arbitrator in respect of joinder of third parties in an arbitration dehorse the group of companies doctrine?
So dehorse the group of companies doctrine, I'll give you an example of a matter which I did in 2018, which is after chlorocontrols but before Cox and Kings, where I had the occasion to appear before the Bombay High Court in the Section 9 proceeding, and then I did appear also partly in the arbitral proceeding. The matter was quite interesting because the petitioner moved against the respondents, 2 of them, in relation to a contract which they had entered into in respect of what is called as HR steel coils. These are steel coils which are used in construction. They are used for roads. They are used for all sorts of very, very large kind of coils, steel coils. And the business of the respondent was to cut those coils and sort of form them. So there was an arrangement between the petitioner and the respondent. There was a dispute which was raised. Section 9 petition was filed before the court. No doubt about the fact that respondent number 1 and respondent number 2 were, you can call them group entities, sister concerns, whatever. And the matter was placed before the court. And when the matter was argued for interim relief, in fact, the respondents made a statement that in relation to the coils which are lying in our godowns to the tune of some 5,000, 10,000 coils, they will not create third-party rights in respect of those coils. So it's a very plain and simple process before the court at the time, and the matter was sort of pushed over to arbitration under Section 17. Now, under Section 17, actually what happened was quite interesting, because as it actually turned out, and shorn of all sort of various facts, and I'm sort of just distilling it for you, as it actually turned out that the coils didn't belong to respondent numbers 1 and 2 at all. So they had in fact given an undertaking in respect of protection of coils, which actually belonged to an entirely different, distinct third party, who was not obviously concerned with the contract between the petitioner on the one hand and these 2 respondents. And the matter proceeded before the arbitrator. When the third party, who actually was the owner of the coil, sought to intervene before the arbitrator said, sorry, you are a third party, you are alien or a stranger to this agreement, you are outside, I cannot help you. And in fact, continued the order which was passed by the Bombay High Court, which was a pro tem order with respect to an injunction, till the pending and final disposal of the arbitral proceeding. So basically, the third party had absolutely no choice. Third party then filed who was the owner actually of the coils, filed an appeal under Section 37 of the Arbitration Act before the Bombay High Court. And a very interesting objection which was raised at that point in time was that, of course, I mean, which is relevant to our present discussion, that the third party, being a stranger entirely to this arrangement, could not have maintained the Section 37 appeal at all. So the arguments which were canvassed before the court, again, which are relevant for the present discussion, obviously were, amongst other arguments, that as opposed to Sections 8, Section 9 and Section 17, which contemplate that only a party to an arbitral proceeding can file a proceeding, Section 37 doesn't have that bar. Section 37, in fact, does not use the word parties because it contemplates that you could have a situation that orders passed under 17 could also affect third parties. And because they could affect third parties, the sort of prohibition or circumscribing of parties is not something which is available in Section 37. And that on that basis, a High Court, in fact, allowed the 37 appeal. It held it to be maintainable. And of course, there were other, like I said, various other facets where the High Court also said you can't leave somebody remediless. You can't file a suit to challenge the 17 order. So all of those facets were considered, but this is a reality. I mean, in every therefore matter, the fact that party autonomy on the one hand and sort of trying to drag a stranger to an arbitration to an arbitral proceeding is the question that therefore arises in every matter. But that's how the court resolved the question there in that matter.
Thank you. Thank you so much for sharing your valuable insights and your enriching personal experience. Now, as we broaden our perspective beyond the Indian jurisprudence, Mr. Purohit, could you please enlighten our audience on the global landscape of the group of companies doctrine and the trends that you have observed in its application on the international stage?
Well, thanks, Faizan. It is an honor to be sharing a panel with two distinguished individuals who I've had the good fortune of working with. Coming back to the doctrine of group of companies in a global context, and before that, joinder of third parties, which is our broad topic. Now, as Gary Bond puts it, arbitration agreements are sometimes argued to apply to non-signatories or parties that did not sign the arbitration agreement, but are nonetheless bound by it. A non-signatory may be subject to an arbitration agreement based on various legal theories, like the group of companies doctrine, alter ego, agency, succession, and estoppel. Now, the group of companies doctrine in an international context was developed in particular by a number of ICC arbitral tribunals, as well as French courts. And notably in the case of Dow Chemicals versus Isover Saint-Gobain, this doctrine was expounded, and the basis for that was the overall circumstances that led to the negotiation of a contract, the performance of that contract, and the termination of that contract. So it basically boils down to the intention of the parties on these three aspects. That is the formation of the contract, the negotiation, and the performance termination thereof. Now, these circumstances in that case, in Dow Chemicals case, intrinsically linked third parties to the contract and to the arbitration. So this is how the, if I may use the phrase, the doctrine was sort of introduced and was used thereafter by various practitioners in arbitration proceedings. Now, an important facet is that arbitration legislations in UK, Australia, Singapore, and Hong Kong recognize that third persons who are non-signatories to an arbitration agreement, but who are claiming through and under a party to the arbitration agreement, have the status of a party. So they are considered to be parties. And we hear more on this claiming through or under later on. Now, as this is generally speaking about third parties, but as far as the group of companies doctrine is concerned, it has had mixed response. So certain national courts have even, in fact, rejected this doctrine. And there was an English court judgment which said that this doctrine forms no part of English law. So this is the other extreme. Now, in 2021, an emergency arbitrator appointed by SIAC applied the group of companies doctrine to array one of the non-signatories as a party to the arbitration. This was the case of Amazon versus Future, where P&A had represented Amazon. Now, the order passed by the EA, wherein the EA applied the group of companies doctrine to array one of the non-signatories as a party, was upheld by the Supreme Court as enforceable under Indian law. So that's briefly the international landscape, really. And it'll be interesting to see, the decision of the larger bench in Cox and Kings and where we arrive. So, yeah.
Thank you, sir. Thank you so much for shedding light on the global perspective of the doctrine. I mean, it's safe to say that not just in India, but even abroad, it's very much in the gray.
Yeah.
Now, I'd like to direct a specific question to Mr. Khandekar. Building on your analysis of the Cox and Kings judgment, could you please share your thoughts on the potential anomalies in the chloro controls judgment that might have prompted the Supreme Court to make a reference to the larger bench in the Cox and Kings case?
Yeah, sure. There, we don't have to guess because the entire judgment of Cox and Kings really proceeds on the basis of how the chloro controls court was incorrect in what the chloro controls court did. So, just to sort of, I don't want to make it too complicated for our audience. At the same time, I think it's important to sort of still nuance it a little bit so that we are all on the same page. So, the findings with respect to the doctrine of group of companies essentially are contained in paragraph 64 to 69 of the chloro control court, of the chloro control judgment. Now, what are the obvious anomalies which the Cox and Kings court recognized was the first aspect which Mr. Behramkamdin also touched upon in the very beginning, as to the introduction of intention of the parties to the agreement to bind a third party to the arbitration agreement. Now, this therefore was quite in that sense really vague, not something which you can sort of in that sense define, not something which you can immediately sort of crystallize, and which is why in 24 of the Cox and Kings judgment, the comment of the Cox and Kings court on the chloro control judgment on this point was that the judgment in chloro control conflates a contractual understanding of the group of companies doctrine, which has evolved within the framework of arbitration without alluding to contractual principles. On the one hand, you say there has to be some legal relationship between parties. On the other, you say that, look, there has to be some intention. The intention has to be gathered from 1, 2, 3, 4. How the intention is to be gathered is not something which perhaps can't even be defined, but that's certainly not defined. So in that sense, it's kept open. So therefore, in the first place, it is not a doctrine which in that sense is quite crystallized, but in that sense quite malleable, which may not really be a good thing at all when there is therefore a lack of certainty. So that's the first point. The second point, which is actually very important, is the aspect of, and which I think a lot of even writing on this has sort of really got it slightly wrong, if I can say so, is that the chloro controls court has not really looked at for inspiration of the group of companies doctrine at claiming through and or under section 45. Because claiming through and or under section 45 was a part of the argument made in chloro controls. The chloro control court did tinker in the first place with the claiming through and or under. But when it came to the conclusion that it's not something which we could find, just Faizan, if you could put paragraph 65 of in fact 66 of the chloro control judgment, which will make this aspect clear, because the judgment starts with paragraph 65 and it will come up on the screen. Though the scope of an arbitration agreement is limited to parties who entered into it and those claiming under it or through them, the courts under English law have in certain cases also applied the group of companies doctrine. So it founded the group of companies doctrine not under 45, but completely dehors 45. Therefore, completely dehors any statutory provision on the basis of something which was otherwise prevalent in certain international sort of jurisdiction, Then, in fact, it went on to examine international jurisdictions, and it said, okay, this judgment says this judgment says this allows it, this doesn't allow it, but no real take on why a particular judgment sort of allows it or doesn't allow it. And in fact, this is exactly, just put on the screen if you can, paragraph 37, which is 41 of the SEC report of Cox and Kings, which precisely identifies this problem. And just see paragraph 37 of Cox and Kings, if you can put up on the screen, which says, I'll read it till the time that it's put up on the screen. It says that it may be noted that the doctrine as expounded requires joining of non-signatories as parties in their own right. This joinder is not premised on non-signatories claiming through and or under. Such joinder has the effect of obliterating commercial reality and the benefits of keeping a subsidiary company distinct. Concepts like single economic entity are economic concepts difficult to be enforced as principles of law. So therefore, it was not with relation to section 45 or claiming through and or under. The problem with the Cox and Kings court had was that you have now founded the group of companies doctrine on something which is completely alien, or rather not something which is statutorily sort of borne out. So that's the second part, which in that sense was a problem, which was identified as an anomaly in the Cox and Kings judgment. The third aspect which I can quickly touch upon is with respect to the fact that what would be the scope at the stage of section 8 or section 11 to actually determine the existence of an arbitration agreement in a situation where you have the applicability of group of companies doctrine. Because in Vidya Dholi, as we know, and the other judgments before that, now it's a prima facie view which is required to be taken. So if a prima facie view is required to be taken in a group of companies doctrine, where now the doctrine requires you to look at the intention of parties and several other factors, is it something which is even possible, viable? If viable, how is it to be done? That's again something which the Chloro Controls Court didn't touch upon at all, and therefore the Cox and Kings Court finds that in that sense as an anomaly. And what it finds as a clear statutory anomaly is the fact that the definition of party in section 21H of the Arbitration Act was not amended after the 256 Law Commission report insofar as chapter 1 was concerned. And as we all know, that a proceeding under 9 or a proceeding under 17, as I just mentioned beforehand, is something which only a party to the arbitration agreement can enforce. So now look at a situation where you want a group of companies doctrine to be applicable to everybody who is a part of group of companies, but therefore you can lump in that third party as a respondent in a group of companies doctrine, but that third party will not be able to initiate a section 9 because it's not a party to the arbitration agreement. So that's again one clear in that sense anomaly which the court has in that sense observed. And the entire tenor of the Cox and Kings judgment is actually sort of, if I can say, it really questions the risk-reward ratio of keeping a floating doctrine such as the group of companies doctrine without anchoring it to any kind of legal or statutory this thing. And what happens also is that there are already settled bases, as Mr. Behramkamdin touched upon in the very beginning, that there are settled bases. For example, assignment, for example, succession, agency, estoppel. So apart from claiming through and or under, you have otherwise also settled bases in international law, in domestic law, where you can enforce an arbitration agreement against a non-signatory. So given all of that, is there really a requirement for a floating software such as floating doctrine such as this at all? Is in that sense the question which the Cox and Kings courts asked, and that's something which has to be answered. Having said that, I may also just want to point out, and I'll just take one more minute on this because I think it's important. And I think the reason also, if I can say so, of Justice Suryakant's slightly tempered approach is because Justice Suryakant was a judge who has also authored the MTNL judgment, or rather the ONGC versus Discovery judgment, where he has developed the group of companies doctrine slightly further, which is reflected in paragraph 83 of the SEC report of Cox and Kings, where he has now given more ingredients which were otherwise missing in the chloro control judgment, such as, again, of course, you have intention there. You can't run away from mutual intent. But mutual intent, relationship of a non-signatory, which is a signatory to the agreement, commonality of subject matter, composite nature of the transaction, and the performance of contract. And what he ties this up with, of course, if you could just look at 93 of this report, where he actually looks at the analysis and he says he opts for a slightly tempered approach, where he says from the analysis above, it appears that joining a third party to an arbitration based on convergence of group of companies as a single economic unit is no longer the norm under group of companies doctrine. Instead, the standard is premised primarily on implied consent drawn from acts and conduct of an entity within the group of companies. Where a closely knit group exists, the interpretation of a third party's intent to be bound by the arbitration would be construed from facts and circumstances specific to that group and in the manner in which functions. It maintains the separate legal personality of the non-signatory and joins it to the arbitration proceeding on the basis of its implied acceptance to be bound. So some kind of, in that sense, via media, where you of course recognize corporate autonomy, corporate independence, corporate personality. At the same time, you look at commercial realities, and I don't think we may have the time for it, but if the audience gets a chance, they must read 93 to 99 of this judgment, where actually Justice Suryakant makes a case for what are really the practical realities and why you can't jettison this doctrine entirely as it was sort of, in that sense, advocated by the majority judgment. And he says that you have to have a slightly tempered approach in going about this. And I do believe that we have traveled far further in Indian jurisprudence, where we've actually utilized this doctrine to sort of varied, in that sense, extent, and therefore entirely jettisoning it perhaps will not serve the purpose. However, like I said, the chloro controls judgment leaves it really open. Judgments after that don't close it at all. In fact, they open it in different diverse directions. And therefore, what is really warranted now is we'll have to wait and see what the larger bench decides and how the contours are defined.
Thank you. Thank you so much, Mr. Khandekar, for the exposition on the anomalies in chloro control. Safe to say that a definitive judgment would be required from the larger bench. Now, turning our attention back to the fundamental principles of Indian arbitration law. Mr. Behramkamdin, we'd appreciate your expertise on a specific aspect. Could you please elaborate on the phrase claiming through or under as it appears in Section 8 of the Arbitration and Conciliation Act?
Yes. So as I mentioned earlier, chloro controls does deal with this claiming through or under the phrase as such. And we have read the relevant parts of it, and I have explained in what context the chloro controls judgment deals with this phrase. But then, of course, we have the Cox and Kings judgment, where one of the issues was to decide the validity of the group of companies doctrine itself. And one of the specific issues was whether the phrase claiming through or under, which is found in sections 8 and 11, can be interpreted to include group of companies doctrine. So that was a specific issue which has now been framed. One of the reasons for framing of these issues, as Rashmin has just pointed out, was that chloro controls, of course, holds what it does, but the doctrine has been expanded and has gone into all kinds of different directions by the judgments which follow chloro controls. And those have all been set out in Cox and Kings. And I want to just have a quick look through at all those judgments. So in paragraph 35, they first talk about, the Supreme Court first talks about Amit Lalchand Shah's case, which was a 2018 judgment. And here, this was a case where there were 4 parties. There were 4 agreements for one single purpose, which was for setting up a solar plant in Uttar Pradesh. And a division bench of the court treated the contracts as interconnected, although the parties were different, yet the agreements were effectuated in light of a single commercial project. So this is again slightly different, because they said what is really important is a single commercial project. And so what if there are 4 different agreements, and so what if there are 4 different parties? And they referred all the parties to arbitration. Then you have the judgment of Charon Properties case, which was a case, as Rashmin again pointed out, where the doctrine was actually used in execution proceedings. And the Supreme Court says that in that case, this court interpreted Section 35 of the Arbitration Act to enforce an award against a non-signatory, even though it did not participate in the proceedings. The next judgment they have relied upon is Reckitt judgment. And here they said that the two-judge bench of this court refused to apply the group of companies doctrine as the applicant failed to prove the commonality of the intention of the respondents to be bound by the arbitration agreement. And finally, they go into MTNL's judgment versus Canara Bank, and it was observed that the group of companies doctrine can be utilized to bind a third party to an arbitration if a tight corporate group structure constituting a single economic reality existed and the court held as under. So this is another test or another sub part of this doctrine which has come up, which is single economic reality. And after all this come the real relevant parts, which is paragraph 39 onwards, where the Supreme Court says, we may notice that these cases have been decided by this court without referring to the ambit of the phrase claiming through or under. So this is where, like Rashmin was saying earlier, the court says, what does the phrase claiming through or under have to do with your whole doctrine? And is your doctrine really based on that phrase or not? That's the whole question. And then in 40, they say, the ratio of chloro controls alludes to the subjective intention of parties to be bound by arbitration agreement when the parties have clearly not been signatory to the agreement. Reconciling the two is difficult and requires exposition by this court. And finally, in 41, they say, it may be noted that the doctrine as expounded requires the joining of non-signatories as parties in their own right. This joinder is not premised on non-signatories claiming through or under. So they say, listen, claiming through or under doesn't seem to have anything to do with the doctrine itself. Though it was mentioned in chloro controls, that's not really the premise on which the judgment was based. And therefore, they say such a joinder has the effect, and therefore they say that concepts like single economic entity are economic concepts difficult to be enforced as principles of law. And then they say that the areas which were left open by the court in chloro controls have created certain broad-based understanding of this doctrine, which may not be suitable and would clearly go against the distinct legal identities of companies and party autonomy itself. This aforesaid exposition clearly indicates an understanding of the doctrine which cannot be sustainable in a jurisdiction which respects party autonomy. There is a clear need for having a relook at the doctrinal ingredients concerning the group of companies doctrine. And therefore, it is on this basis that the Supreme Court then later on goes to say that we need to have a complete look at it. It also does, if I have a couple of minutes, I just want to point out two other judgments of foreign courts which has gone into. Please. So in paragraph 44, they are citing Peterson's case. And they say an arbitral award was challenged, wherein the claimant received damages on its behalf as well as on behalf of its group entity before the Queen's Bench Division. Court partly set aside the award and stated that the group of companies doctrine does not form a part of English law. I think this is what Vijay was referring to when he said there's an English judgment which actually doesn't accept the doctrine. And in paragraph 45, they talk about the High Court of Australia in Tanning Research case, where they say a person who claims through or under a party may be either a person seeking to enforce or a person seeking to resist the enforcement of the alleged contractual right. Subject of the claim may be either a cause of action or a ground of defense. The prepositions through and under convey the notion of a derivative cause of action or ground of defense. That is to say, a cause of action or ground of defense derived from the party. In other words, an essential element of the cause of action or defense must be or must have been vested in or exercisable by the party before the person claiming through or under the party can rely on the cause of action or ground of defense. So they say whenever there's claiming through or under, there must have been a right in somebody else first, and that right has passed on to the other person, which is why you say claiming through or under. And this is the exposition they have given. And then in paragraphs 49 and 50, of course, the court has also gone on to say that an arbitration agreement may be binding on the parties, whether signatories or non-signatories, provided there is sufficient legal basis to bind them. Most legal basis for binding non-signatories to an arbitration agreement are of contractual origin. like agency, etc. Jurisprudence has shown that arbitration, being a creature of contract, does not sit very well in binding non-signatories. Expounding on the same, and then they go on to what Professor William Park has said, etc. And then finally, they say that it is evident from the discussion above that the group of companies doctrine must be applied with caution, and mere fact that a non-signatory is a member of a group of affiliated companies will not be sufficient to claim extension of the arbitration agreement to the non-signatory. And then, of course, they cite Gary Bond. And I just want to read a little bit of what Gary Bond has said, where he says that another significant but controversial basis for binding non-signatories to an arbitration agreement in the group of companies doctrine is the group of companies doctrine. Under this principle, non-signatories may be deemed parties to the associates arbitral clause based on factors which are often roughly comparable to those relevant to an alter ego analysis. In particular, where a company is a part of corporate group, is subject to the control or controls of a corporation affiliate that has executed a contract and is involved in the negotiation of the contract or the performance of the contract, then that company may in some circumstances invoke or be subject to an arbitration clause contained in that contract. Then he says, unlike other cases for binding a non-signatory to an arbitration agreement, such as agency, alter ego, or estoppel or third-party beneficiary, the group of companies doctrine was developed specifically in the arbitration context and is not typically invoked outside that context. At least thus far, the group of companies doctrine has also been explicitly accepted only in a limited number of jurisdictions, in particular as discussed below, France. And in part for that reason, the doctrine has given rise to substantial controversy. So the Supreme Court recites all this, relies on all this, and eventually for various reasons, which are set out in the paragraphs, subsequent paragraphs of this judgment, have referred to the issue in terms of the questions which they have framed.
Thank you, sir. Thank you so much for emphasizing on the nuances of this provision. As we pivot back to the international landscape, Mr. Purohit, we're eager to hear from you once again. Please enlighten us on the relationship between the group of companies doctrine and the doctrine of alter ego in international commercial arbitration. Are these concepts interchangeable, or do they possess distinctive aspects that require further exploration?
Thanks, Faizan. Mr. Behramkamdin did touch briefly on this aspect while quoting Gary Bond. And here again, I'd like to go back to Gary Bond. See, the doctrine of alter ego relates more to attribution and to pierce the corporate veil as against the group of companies doctrine. And as Gary puts it, demonstrating an alter ego relationship in most legal systems require convincing evidence that one entity dominated the day-to-day transactions of another, and that it exercised this power to work fraud or other injustices on a third party, or to evade statutory or other obligations. Now, when you apply the group of companies doctrine, the factors that may lead to non-signatories being associated with an arbitration clause are, as Mr. Behramkamdin rightly said, and as Gary Bond puts it, are roughly comparable with the alter ego doctrine. While the end goal of both the doctrines is to bring non-signatories to the fold, within the realm of an arbitration clause, but the applicability of these doctrines differ fundamentally. On one hand, you have piercing of corporate veil versus the intention of the parties during the contract, its performance, and the termination of the contract, as I pointed out earlier. Now, in alter ego, a court or a tribunal may conclude that a third party is bound by an arbitration agreement where there is evidence that the party to the agreement is being used merely as a facade or a front in order to or conceal any liability, to avoid or conceal any liability. So there's one notable judgment of the Supreme Court of Singapore in this regard, which is Aloe Vera of America Inc. US versus Asianic Foods Private Limited, where the Supreme Court of Singapore held that whether a person is the alter ego of a company is an issue that does not have a public interest element, so is within the scope of arbitration and is therefore arbitrable. So while the two doctrines may uncannily look similar, and as I said, the objective is the same, to bring a third party into the fold, but the applicability is different. On one hand, we are trying to explore who were the real players or the dramatis personae in a transaction, right? And on the other, it is a pure contract law inquiry into what led to the negotiations, how was the contract formed, how was it performed, who were the parties who were supposed to perform the contract. It does not have an element of a facade or a fraud, right? So there is this basic difference between the two doctrines, although in several references they are interchangeably used. Doctrine of group of companies stroke alter ego, but in essence they are not the same. Their objective may be the same, but they are not one and the same. So that would be my take on it. You are on mute, Faizan.
Sorry. Thank you for your comprehensive response. Since we are near the conclusion of our panel discussion, I'd like to extend an invitation to our audience. If you have any questions for our speakers, please submit them in the chat box. Unfortunately, since we are short on time right now, we may have to draw this session to a close, but we would be happy to get back to you on email. If you could drop us an email as well, or in the chat box, we'd be happy to get back to you. At this juncture, I would like to extend our heartfelt gratitude to our distinguished speakers. We greatly appreciate your contribution towards the subject of this seminar. And to our audience, thank you for joining us today. We hope this dialogue has enriched your understanding and provided valuable takeaways. We wish you a productive evening ahead. Thank you.
Thank you, Faizan. Thank you for having me.
Thank you. Thank you.
Thank you so much. Thank you, sir.